All right, I'd like to call the special meeting of the Milton City Council for Monday, August 9th, 2010 to order. Will the city clerk please call the roll and make general announcements?
Good evening, Mayor Pro Tem and Council. I'll be happy to call roll for the August 9th, 2010 special called meeting. However, I would like to remind those in attendance to please silence all cell phones at this time. Additionally, those attending the meeting who would like to provide public comment during the call for public comment, you are required to complete a public comment card prior to speaking on an item. There is no public comment for consent agenda items or items under first presentation. Those called to speak will be taken in the order that the speaker cards were received by the city clerk staff prior to the beginning of tonight's meeting. All speakers will identify themselves by name, address, and organization if applicable. When you hear the bell, you will have 30 seconds to complete your remarks. The City Council may allow public comment on either an agenda item or general public comment from a representative of such an organized group or association, provided, however, that such an individual shall file a notarized affidavit that they have the authority to speak on behalf of said organization on a form provided by the city clerk prior to the agenda item being called. Demonstration of any sort within the chamber is prohibited, so please refrain from any applause, cheering, booing, outbursts, or dialogue with any person speaking. Please show the same respect to the person speaking that you will expect to receive yourself. Anyone in violation will be asked to leave. As I call roll, please confirm your attendance. Mayor Joe Lockwood is excused and absent. Councilmember Karen Thurman.
Here.
Councilmember Julie Zonner-Bailey.
Here.
Councilmember Bill Luss.
Here.
Mayor Pro Tem Burt Hewitt.
Here.
Councilmember Joe Longoria.
Here.
Councilmember Alan Tart.
Here.
Would everyone please rise for the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All righty, will the clerk please sound the next item?
Next item is approval of meeting agenda. Agenda item number 10-1203.
Are there any other items to be considered for the agenda?
No, they're not.
All right, is there a motion and a second to approve the agenda?
I'll make a motion that we approve the agenda as presented, agenda item number 10-1203.
Second motion.
All right, we have a motion to approve the meeting agenda made by Councilperson Thurman and seconded by Councilperson Lusk. Is there any discussion? All those in favor, please say aye. Aye. All right, motion passes. The next item is public comment. The public comment is a time for citizens to share information with the mayor and city council and to provide input and opinions on any matter that is not scheduled for its own public hearing during today's meeting. Each citizen who chooses to participate in public comment must complete a comment card and submit it to the city clerk. Please remember that this is not a time to engage the mayor or members of the city council in conversation. When your name is called, please come forward and speak into the microphone stating your name and address for the records. You will have 5 minutes for remarks. City clerk, is there any public comment?
There is no general public comment, sir.
Okay. Moving on to the first presentation, will the city clerk please sound the item?
An ordinance of the mayor and council of the city of Milton, Georgia, to fix the ad valorem tax rate of the city of Milton for fiscal year 2010 and for other purposes. This is agenda item number 10-1204.
All righty. Is there a motion and a second?
Mayor Pro Tem, I'll put forward a motion to approve the first presentation of agenda number 10-1204.
Second.
All right, we have a motion by Councilperson Zonner-Bailey and seconded by Councilperson Tart to approve the first presentation item. All those in favor, please say aye.
Aye.
Any opposed? No. All right. Moving on to unfinished business. Will the city clerk please sound the item?
Approval of an ordinance to replace Chapter 54, regulating the location, placement, and leasing of wireless telecommunications facilities. Agenda item number 10-1161. Previously discussed at June 14th council work session. First presentation on June 21st regular council meeting. Deferred from July and August regular council meetings. Ms. Lynn Tully, we do have 3 public comments, Mayor Pro Tem.
Would it be best to go ahead and let those public comments? All right, let's go ahead, please.
The first speaker will be Dennis Boyden.
Good evening. Dennis Boyden, Regional Director, AT&T External Affairs, and I'd like to thank you all for this opportunity to speak on behalf of AT&T. I'm speaking in reference directly to the ordinance revisions plan for cell towers. On Friday, August the 6th, one of our attorneys, Ms. Dorian Denberg, sent an email to City Attorney Jarrett along with a copy to each of you about our ongoing concerns regarding proposed revisions for this ordinance. I know this has been a prolonged process, but certainly, again, we hope that there is an opportunity tonight for discussion about those issues as it relates to application fees, annual license fees, and the requirement of PE engineers. We fully understand that you, as elected officials, first priority is to protect your citizenry as well as the aesthetics concerns of the city, and we respect that. And believe me, we know firsthand in the current ordinance that is in place, it is a high bar to move forward with a cell tower, but that is a capital and investment that we, along with other representatives here for their respective companies, have made in the process and would like to continue to make. We also respect the fact that in looking to bring in consultants, that is certainly something that you can look to do. But we also are very knowledgeable of the fact that within this process, your planning commission thus far has been more than adequate to do what they need to do, your knowledge of the process. And we're also keenly aware of the fact that amongst your peers, Mr. Bill Lusk is an engineer, PE certified. So we respect the fact of the knowledge that you bring along with the representatives that want to consult on your behalf. But I hope we don't forget in the process that we also bring the expertise too. In fact, we're the ones, along with you, that have made the capital investment into this city. And so we ask tonight, as these issues are discussed, that if given the opportunity, if additional comment need to be made to clarify a point, that you provide such an opportunity. We don't want to continue delaying this process, but hopefully from the information that Ms. Denberg has provided, along with other correspondence that you have gotten, along with any additional information that you hear tonight, to please know that we are very concerned about the aspects of our business, and please know we're not going to make the type investment that's required in a cell tower and then walk away from it or put the safety of your citizenry at risk, along with fellow employees that we have that are residents in the city of Milton as well. And finally, this point is, when you look at the fees, there's a front end and there's a back end. There's a front end for the fee to apply for a tower, and then with the rigorous process that's required to get a tower, then on the back end you come back and, well, if no one's applying for towers, then there's a fee on the back end under the term of an annual license. And so we really would like clarification, as was stated by Ms. Denberg, about what are those fees? What will they actually inspect of our property in your community? And we just hope that we can get some clarification to this evening. And with that said, I'll stop at this moment, but hope that you will allow for that time. Again, we do not want to delay and continue to delay this process, but it is of great concern to us, and we certainly appreciate your providing this time. Thank you.
Sir, would you state your address, please, for the record? I don't believe you got the
Yes,
address.
my office, sir, is located at 675 West Peachtree Street, downtown Atlanta, 30375. And it is noted on the form, Mayor Hewitt. Thank you, sir.
Our next public comment comes from Ellen Smith.
Good evening, City Council members. My name is Ellen Smith. I'm an attorney at Holt, Ney, Zack, Coffin, Wasserman. It's a mouthful. 100 Galleria Parkway, Suite 600, Atlanta, Georgia. And I'm here tonight on behalf of the Georgia Wireless Association. I'm the co-chair of the Regulatory Committee. And first I want to say thank you. I know that you all have heard comments, you've received letters, you've received emails. I know the planning director has as well, and you're getting more comments tonight. Hopefully the fact that you're hearing both from the Wireless Association and from members of the industry lets you know that, number one, we're paying attention to the city of Milton. It's an important jurisdiction in the state for wireless coverage. The carriers, not only the AT&Ts, the Verizons, the T-Mobiles, the Metro PCSs, but also the tower owners are paying attention to what's happening in your city. And I just want to echo the concerns that you've already heard and point out just two very important things. One is the requirement that you have in Section 5 of the ordinance for a study to be submitted that deals with coverage, and for that study to be certified by a PE. And the reason that I point that out to you is because, and you know the requirements for a PE much better than I do, I think that a civil engineer will give you a certification of that kind of coverage study, but it's going to have any number of qualifications in it. It's going to say, I'm not a radio frequency engineer, probably. It's going to say I'm not qualified or licensed to deal with radio frequency matters. And I just humbly suggest to you that you ought to strike out the requirement that it be certified by a PE. Your other language in Article 5 requires a radio frequency engineer to certify information to you. Other jurisdictions handle radio frequency analysis by requiring, an affidavit from that radio frequency engineer. You certainly could require the radio frequency engineer give you his credentials or her credentials. But to have a PE certified to it, you're getting an engineer who is not specialized in radio frequency to certify to a study. So really it's not getting you anything from a practical standpoint. We have no problem with the requirement that you get a study, just how you get it is the concern we have. The second thing that I would urge you to reconsider is the last thing that Dennis mentioned, which is the requirement for an annual license fee. Number one, we would like clarification as to what the fees are in totality. The carriers are willing and tower owners are willing to put up a substantial application fee up front. They're putting the capital investment in. But to require an annual licensing fee, number one, that's not a specified dollar amount, is a little scary. But number two, if they don't pay it, or if there's a transfer of the tower and somebody misses it for the year, not only could they be subject to paying that fee, whatever the amount is, but they also potentially could be subject to misdemeanor in the city court, and that could be day-for-day fees. And I think that's a little bit harsh considering the initial capital investment that they're giving, and I just ask you to consider the reasoning for that requirement as you go forward. Thank you very much, and we appreciate all the work that you're putting into this.
Our final public comment comes from Jennifer Blackburn.
Mayor, members of the City Council, my name is Jen Blackburn. I'm an attorney with Troutman Sanders, and I'm here on behalf of Verizon Wireless. My office is at 600 Peachtree Street, Suite 5200, Atlanta, Georgia, 30308. I'd like to echo both Ellen and Dennis' concerns. First, I'd like to thank you very much. The city attorney, as well as Ms. Tully, has worked with us and reviewed our comments, and we do appreciate that. We're very happy with the changes that have been made as it relates to the Georgia Broadband Co-location Act. I think we've got that section revised so that both the carriers as well as the city is comfortable with it, and we're very, very happy about that. The only two areas of concern, while they're very serious concerns to the industry, are what Ellen mentioned, which is the requirement of a PE on radio frequency engineer materials. It requires a Georgia licensed PE sign off on RF radio frequency information. Georgia does not have a specific license for radio frequency engineers, so that would require us to get a PE, which is generally a structural engineer, to sign off on the radio frequency engineer information. And as Ellen was explaining, it presents a bit of a problem. For Verizon, I know that we have all of our RF engineers, they're not Georgia certified because it's not required in the state. So while they're schooled in radio frequency engineers and experts in that area and could certainly provide you with a resume or an affidavit as to their experience, we wouldn't be able to submit their information directly to you. We would have to then go and get a PE that isn't specialized in radio frequency engineer information to then sign off on that. And so it seems like an extra step that just really does not does not seem to benefit the city or the industry or anyone in that point. So we would request that section 5, be revised to just require that it be a trained radio frequency engineer, or the language that was originally in draft 1 we did not object to, and I can't remember exactly what it said, but it was basically that it would just be an experienced radio frequency engineer. Our second objection would be to the annual licensing fee. As I believe you guys know, we are required to maintain a license every year from the FCC. So I think that this provision, the city wants to just be sure who all's on the tower, how many carriers are in the tower, and make sure you have your records straight. The tower owner could easily submit an affidavit every year to do that. We do not feel that that's something that requires a third-party consultant to go out and look at the tower. We could submit an affidavit swearing to the number of people that were on the tower, and that way you guys could make sure that you have your records correct for tax purposes, things like that, and it wouldn't be hitting the industry or the tower owner with, whatever that fee. It isn't specified. I think that some people were throwing around a number, I believe I heard around $1,000 per carrier, which for the number of towers we have, that would be a huge, huge, huge cost to the carriers. So we would suggest that instead of requiring a consultant to go out and look at the tower, which basically it would just be a site, they go out and see how many carriers are on there, the tower owner could submit an affidavit saying these are who is on our towers, and that way you could keep your records updated according to that. So again, I appreciate you listening to our comments and reading our comments we've sent you, and I'm here to answer any questions you may have. Thank you.
Thank you. That's all of our public
Yes, sir.
comment. All right. Who wants to run with this one first?
Mayor Pro Tem, I will take this one. Mayor Pro Tem, members of the council, we're here this evening at a special meeting to take up and hopefully approve the Milton telecommunications ordinance amendments that we've been working on for so long. I will tell you this has been a bit of a tortured process, but that is the way it goes when you do reach out to the industry and try and listen meaningfully to their comments, which we have done. And we haven't just listened. We have tried to do what we can to modify the code if we felt that was appropriate. We also have our own experts and consultants that we have gone through these proposed modifications with multiple times. And in addition to that, Ms. Tully and I have sat down and gone through almost line by line the code again. And that was the reason, if you recall, that we did not take it up for a vote at the last meeting, was to allow us to do that. We feel like we have the makings of a very good ordinance now. We feel like it has been reviewed and re-reviewed and viewed again. As you can see, there is a common theme from the industry, and what we're hearing is there are two issues that continue to cause the industry concern, which is really remarkable given the length of this ordinance that we've got it down to just two. So actually, I think that's sort of a positive thing, quite frankly. The two issues are, if you'll turn on the draft that I handed out to you this evening, if you'll turn to page 5, it's the issue of this radio frequency engineer. And I have talked at length both to attorneys for the industry as well as our own experts and attorneys, as well as to Ms. Tully and even to the city manager with respect to that. And, no one wants to be so dogmatic that we don't listen and impose something for no reason other than we want to impose it. So we tried to listen with an eye toward being flexible if flexibility was warranted. If you look on page 5, what I am proposing with you tonight, and again, most of this you have seen, so all I'm going to talk to you about this evening is things that perhaps may be a little different than the last version you looked at, was proposing a different definition of radio frequency engineer. Obviously, the City of Milton has an interest in ensuring that a professional certified engineer in the state of Georgia signs off on plans that pertain particularly to the issue of the weight loading and the structural integrity of facilities. And Ms. Tully and I spoke today, and we agreed and were unanimous on that conclusion that we will not budge a bit about that, because obviously that goes to the public safety, which is our guiding thing we want to preserve. However, It also appears that with respect to the propagation studies and some of the other technical elements, that perhaps a PE is not necessary in those sorts of situations, and in fact, perhaps simply a certification from an individual with specialized training and experience in the development and analysis of telecommunications networks and facilities may be appropriate. So what I have done is I have tweaked the definition of radio frequency engineer to provide that either we will have to get a certification from someone with specialized training and experience in the development and analysis of telecommunications network and facilities, or a professional engineer licensed in the state of Georgia. And then you'll note on the fourth line down, that in the event that this ordinance requires an engineer certification regarding structural loading or other certification associated with the safety or integrity of structures, a certification by a PE licensed in the state of Georgia shall be required. And if we go through the ordinance this evening and you look at every instances where a radio frequency engineer is required or a PE, I believe what it will do will be to give staff the discretion that if it is in the realm of propagation studies, coverage, those sorts of areas, that the more, what I would call more liberal definition of radio frequency engineer can be used. However, if it is associated with structural loading or integrity, then a professional engineer certification will be required. And I think that would be in the, quite frankly, in the discretion of Ms. Tully to make that determination as to which one is required. And I think that if she's comfortable with that, I'm comfortable with that. I think the industry would be comfortable with that. And I think we will have perhaps worked out a compromise that makes sense. So that's what I'm proposing to do. Ms. Lynn? Yeah. So let me keep going. That's on page 5.
Do you want to, if you've got any questions on it, you want to go ahead and entertain those now? Okay, go ahead, Joe.
The only question I had here, and I certainly understand everything, and I'm on board with everything he said. If we appear to be in the definition section
Yes.
of this ordinance,
Yes.
and it seems strange that we put in some language that goes beyond just the definition of what a radio frequency engineer is here. So I was wondering, were you trying to cover a base there?
What do you mean with respect to the however language?
Yeah, the however language. Normally under definitions, you just say a radio frequency engineer is somebody trained in understanding radio frequencies.
It's part of the ordinance.
Okay.
And it's a fair question, but it's part of the code. And to the extent that we have an issue arise as to what was meant later in the code,
Okay.
the community development staff can go back and say that it's my call and my discretion if there's an issue.
I'm good with that.
That's fair.
Sorry.
Councilperson Zonner Bailey.
Thank you, Mayor Pro Tem. With regards to radio frequency expert, the fact that it doesn't further define what that expertise would be, it seems a little bit broad.
It is.
Would there be additional language that would help to be more specific? Short of the PE certification, I understand that issue. I think that this obviously works towards a positive compromise. That would be my question with this definition, is just whether or not you need to define specifically what that expertise needs to require.
Let me offer up this by way of a response. The industry is going to be required to put their file together and submit their information to us and rely on those people and those experts that they believe that they can have confidence in to give us the right information. As you know, one of the reasons that the application fee in this code is what it is because the city on our end will be reviewing and having these applications looked at by our own experts. So this council will not be in a situation where we are relying upon someone that, Councilmember Zonner Bailey, to your point, may not have the appropriate credentials or the training or whatever to make this sort of a call. If that's who the industry wants to put up as the people that are guiding them and giving you the information, I think that's up to them. And we will then in turn put up people and provide you further guidance that we believe are credentialed and can give you that information. So I guess my thought is as long as we call out what their specialization needs to be, what the training needs to be, and the sort of information we need to have, if they choose to put up someone that may not be as credentialed as we think they should be, I think that that's probably their problem.
And I think that's fair. And short of having our speakers come back up, perhaps separate from this evening, if there's any specific, short of that PE certification, if there's anything that represents a standard, because there may be between AT&T and Verizon and the Georgia Wireless Association, that there's some things that just define that might be helpful to provide. So at least on a case-by-case basis, we know what we're looking for when we're looking at that.
And it's a good point, and it's the reason that I think that, particularly on our side of the fence, the city staff, that we were comfortable with the PE. It's a known entity. It's got the certifications. It's got the stamp. The industry obviously was very uncomfortable with that, and that has been a constant theme of their comments back and forth. And so, obviously, trying to narrow a specific sort of specialty without having any objective criteria like a licensure is challenging.
Councilperson Lusk?
I agree with your definition as written. I think what we're talking about as far as radio frequency experts or engineers doesn't carry the same element of public safety as the structural part of the facility is concerned. We're talking about structural stability in a tower, and we're talking about something entirely different with radio frequency that doesn't have the safety of the public really involved in it. I'll go along with the way it's written.
And in fact, may I just answer that real quick? The only thing I was going to say is on page 10, if you look at it's C6 to Councilmember Lusk's point, when we're talking about the structural integrity analysis, that is, of course, a PE. So, again, that's where we want to be very clear. Councilmember, sorry.
And just to clarify, my understanding is in instances when that radio frequency expert is needed, absolutely, to Councilmember Lusk's point, it's not about the integrity of the structure, but it's in part the proof, if you will, of what we're requiring to even be able to evaluate whether or not that telecommunications structure is perhaps needed. I know that when we've had some cases that's really where that expertise is important to the justification for the tower in the first place. So that's one reason I suggest that understanding, does the expertise come after 5 years of training? Again, we don't have Georgia certification, I understand that. I'll just end with that point, that it would be helpful perhaps to at least provide information in terms of how the industry would define expertise so we know what to look for in the future.
I don't disagree with that a bit, and I will simply say, though, again, that if they provide, first of all, I mean, they have no reason to get that wrong, because obviously approaching this council trying to get one of these towers is an onerous enough task anyway, and to try and, if they get that information wrong, then that's going to be a problem for them.
Go ahead, Bill.
Back again on the element of consistency here, we spoke about the other day, professional and engineer are proper nouns, therefore should be capitalized throughout.
Agreed. So the reference to professional engineer on paragraph 6 on page 10 should be capitalized. PE, I understand.
Right, and throughout the entire text here, there's inconsistencies.
Are there any other comments on the radio frequency section?
Well, I was going to say along that same line, radio frequency is one word in the definition section, and it's a separated word as you read throughout. Radio and frequency are two different words. And I would just, I trust your judgment, Mr. Gerard. I've never seen us mandate a requirement in the definition section in terms of radio frequency in that second section, or the second part that begins with however.
On page 5.
Yeah, as Councilmember Longoria pointed out, I guess in my experience in writing and interpreting the ordinances and laws, well, laws in particular, you should be able to, every place where it says radio frequency engineer, you should be able to insert this definition and it mean the same thing. And in fact, what we've done by adding this however here, it almost is if we have established a requirement in the definition itself. But if you think that's okay, then
what we have done is you can insert that definition throughout, but when it requires or when it's speaking to the issue of structural integrity, it only can only mean one thing. Everywhere else, it can mean two things.
And as you're saying, it's in this, we're adopting this document, not a portion thereof, so it's taken care of there. Do we have any more comments or questions on this section before we move on to Ken's next point? Okay, go ahead.
The next section I just want to point out to you is on page 8, section 5, and that is where I think we further address the issue of the Advanced Broadband Act, where we made very clear with respect to the permitting process, when we were talking about co-locations or modifications under this new state statute, they have, and there is incorporated into this code, an expedited permitting process that is made abundantly clear. And in Section 5, actually, if you follow it and go back to where it is triggered to 7A, if you flip back to 7A, you will see where the permitting process is quite abbreviated, as we believe the law requires. But you will also see that there are exemptions. So even if there is the applicability or the availability of this expedited permitting process, even under the law, there are exemptions to that. On page 16, you will see that even though co-location or modification are entitled to this expedited process, you will see 4 exemptions if the proposed co-location increases the overall height or width, if the proposed co-location increases the dimensions of the equipment, if the proposed co-location does not comply with applicable conditions. This is all straight out of the Georgia Code. And so it's all been put in here, quite frankly, for just ease of reading and to make sure everyone understands that even though they will be entitled to this expedited approval process, if you trigger these conditions, you do not get that. You have to go back through the more elongated process. I want to speak very briefly on page 12 at the top pertaining to setbacks. We had some council member feedback with respect to potentially allowing stealth technology to be used as a basis to lessen or allow for a variance of the 3,500-foot setback. And quite frankly, after reviewing it and reviewing it again and thinking about it and dissecting it, we've taken that out altogether. And so simply to provide that the 3,500-foot setback is the setback. And it's clean, it's easy to enforce, and that's the way we have left it at the present time. I'm going to move on now because we've already talked about Section 7. I want to move on to page 19. That is the annual license fee. Again, just like radio frequency engineer, the issue of the annual license fee continues to be a concern by the industry. At the present time, let me just state that we continue to be comfortable with the annual license fee. There are a lot of different industries that have annual license fees, annual renewals, and they seem to be able to comply with them with little difficulty. The reality is that this city, as a function of your police power and also your requirement to ensure the public health, safety, and welfare, have the ability to go out and conduct and have the, quite frankly, if not the duty, at least the responsibility to go out and inspect these facilities, not only for safety reasons, but as the speakers indicated, to ensure that the equipment that we have records of that is installed on those facilities is in fact what is installed on those facilities, for purposes not only to make sure permitting has been complied with, but also for taxation purposes. And Milton is a city that I think runs very lean from a staffing perspective, and therefore the way that we have proposed to do this is with a third-party consultant. And that third-party consultant will have to be paid. And it is appropriate that the industry provide the annual licensing that will serve as the basis by which they are paid. The City of Milton is mindful that we cannot impose a fee as a cloaked tax. And we understand that. And this is not to make money. This is to provide this service. This is to provide feedback to the Community Development Director and the City Manager, and ultimately to you. Now, it may be that when we get into this and have some experience with it and enough reports and enough annual inspections are accomplished, we may determine that it's not needed. We may determine that there's no longer a need for these annual inspections. But until that time, and I think based upon just the information that we've received from various parties, I think that the feeling of staff is this is where we want to be. And we want to impose this. And This is going to be information that will help this council, we hope, make better decisions about these sorts of towers and about the public health, safety, and welfare. So that's where we are. We have included some language in this paragraph C, that provides that this license shall serve as a mechanism for obtaining current information regarding telecommunication permit holders and annually inspecting and documenting the condition of permitted towers, antennas, and other telecommunications facilities. A little farther down, we have added language that says that all telecommunications towers, each antenna array located thereon. Now, the word array is different. Used to just simply say antenna, but the word array was something that we talked about with our consultants. They were very comfortable doing that and believe that that will make the license system a little more fair. So that's the way it would be right now. So right now, upon the adoption of this code, we will be requiring each antenna, each tower permit holder, each antenna array, and any array located on a rooftop or other location to have a separate license. And the fee has not been determined yet, and the fee will be put together and issued to the industry before the first annual permitting cycle occurs.
Go ahead, Councilperson Longoria.
Yes. Ken, I mean, we're not, developing something new here. I mean, there are cities and jurisdictions around us that do this the same way. Okay?
My understanding is that there are, and then they're receiving this same sort of feedback from the industry.
I guess my question is, there were two concerns regarding the licensing fee, and I'm in 100% agreement that this is something that's going to cost us, and so we shouldn't just pay for it ourselves. We should ask the people that are benefiting from this to pay a portion of this or pay it all. But I guess my point is, the concern was the fee, and the concern was the lack of knowledge of what the fee was going to be. I think of those two, the lack of knowledge of what the fee was going to be is probably the scarier item, because you don't know if it's going to be $100, you don't know if it's going to be $1,000, and there's a huge swing there. It's an order of magnitude difference. So it wasn't there someplace we could go, some jurisdiction nearby that does something similar to this, that has some history on what this kind of stuff costs, or couldn't we have gotten with potential vendors that could do this kind of service? You give us an idea what it was going to cost so that we could at least take care of the unknown piece of this?
Yeah, I think there is. I think two things. First of all, I think the folks that want to potentially do the service may, in some respects, fashion their fee based upon the volume, the number of inspections they'll be doing in a jurisdiction. That's very common. I mean, obviously, volume, the lower you go, the less the volume. It might be a little higher. Again, it's going to be based on business practices. I think I heard one of the speakers mention that something around $1,000 a year, maybe. I think that's probably in the ballpark, although it may be less than that. But again, I don't think where anyone is contemplating some figure that should be prohibitive or should be have any meaningful impact.
And we're looking at, I'm sorry, but just passing basically, for the most part, actual costs.
Yes.
Is not a.
That's absolutely the case. This will be a pass-through, quite frankly, to pay those individuals that will basically go out and conduct the actual inspections themselves. And obviously, I think that the city staff will work to ensure that we get the most bang for our buck, and then pass that savings along to the industry.
Let's just start down the line, if that's all right, Councilperson Thurman.
I'm assuming that since this is considered a license, we will have to set the amount, though, up front when we set our other licensing fees?
Yes. Yes.
Okay.
It will not, there'll be nothing arbitrary or unknown
That's
about
what
it.
I'll
It
make
will
sure.
be set by council action.
So we'll probably have to get some kind of idea how much this will cost us so that we will know how to set it. And we'll set this with our fees that we set every single year.
Yes, ma'am.
Yes.
Yes, ma'am.
Councilperson Sonner Bailey.
Thank you. Just thanks to everybody. Obviously, a tremendous amount of time and dedication has gone in, both from the industry as well as from our staff and from our city attorney. I do believe, as has been mentioned by Councilman Longoria, that ensuring that the cost to manage and maintain and identify for public safety as well as for need, that cost needs to be shared by the industry that does in fact benefit from the services of our citizens. So I think that this seems to be a fair approach. I think that it's very important that hopefully the industry members here tonight take away that this will not be arbitrary. There will be adequate and sufficient and very financially grounded evaluation in terms of what that fee will be, and the industry will know it in advance. And I think that that's important. So I think that that does, in part, address the issue that was raised this evening. So thank you.
Councilperson Lawson.
Going to your term here in the 7th line where it starts out inspecting and documenting the condition of permitted towers. Leaves it kind of wide open. It's vague. Doesn't really establish any parameters as far as what the inspection includes or excludes, and who it's to be done by. So I think here again, it probably would make more sense that that's where an engineer, professional engineer, would do the inspecting and inspecting the structural integrity of the entire facility.
I think, first of all, the inclusion of that language was not to give the parameters of a scope of work for the consultants. It was simply to provide, in the event that there are third parties reviewing this ordinance, to provide the rationale for why we're doing this, because that's one of the reasons. That's one of the industry comments we've received back is why? What are you doing? And so the thought was, well, let's put some arguably generic language in there stating that we're inspecting. We're inspecting the condition, and we're inspecting to document what's on the tower and the condition of the towers. Now, this council will at some point in the upcoming months be presented with ostensibly some scope and recommendations from folks who want to do these inspections that will be much more specific as to what they are going to be looking for. Will it be the condition of the tower that says yes, but it will be much more specific than that, and will provide this, I think, council a comfort level of what they are going to be looking at on each tower. It's a fair question. Sure.
Is that all you have?
Yes.
Joe, you have anything else?
No.
Alan, do you have any other comments you'd like to?
No, thank you.
All right, Ken, do you have anything else?
Council members, quite frankly, that is the lion's share of the things that are different. Again, just going through with you, we have worked with the industry, spoken with them at length this week, spoken with Ms. Tully, and this is what we're here to provide you with tonight. We think it is a good ordinance. It is a solid ordinance. It's an ordinance that I suspect has been vetted as much as any telecommunication ordinance in this state has been. And I would respectfully request this council give strong consideration to approve it.
Does anybody else have any other questions or comments they'd like to make? If not, we'll entertain a motion. Go ahead, Councilperson Zonner Bailey.
Thank you so much. One quick question, and I believe it's in here, but given that we had another or additional document given to us tonight, I just wanted to verify that for notification purposes, the language does mirror that for a rezoning, and that it's not just distance, but also up to a certain number of citizens that would be notified.
That's correct.
Thank you.
And I will just say that if the council does approve, I am mindful of the consistencies on the professional engineer, and the radio frequency will be modified in the final version.
And I'd just like to say we appreciate the input that the industry has given us, and I hope that we've gotten a lot better document because of your input, and look forward to continuing to work with you. That being said, if anybody's got a motion.
I'll make the motion.
Okay, Councilperson Tarr, go ahead, please.
Mayor Pro Tem, I'd make the motion to approve an ordinance to replace Chapter 54, regulating the location, placement, and leasing of wireless telecommunications facilities, and specifically I'm talking about the August 9, 2010 version that we were presented tonight, agenda item 10-1161.
Second the motion.
All right, we have a motion and a second made by Councilperson Tartt, seconded by Councilperson Lusk, to approve an ordinance to replace Chapter 54, regulating the location, placement, and leasing of wireless telecommunication facilities. All those in favor, please say aye.
Aye.
Any opposed? The motion passes.
Thank you.
That concludes the special call meeting. Is there a motion we adjourn?
So moved.
Second.
All right, got a motion to adjourn by Councilperson Thurman, seconded by Councilperson Zonner Bailey. All those in favor, please say aye. Aye. Opposed? Thank you very much.